Hello, this is the AI Lab. Today it's my pleasure to welcome Kevin Frazier. Kevin is an AI Innovation and Law Fellow at the Austin School of Law of the University of Texas. He is also a contributing editor at Lawfare, a nonprofit publication, and he developed the first open source law and AI syllabus. The reason? A recent article by Kevin entitled Progress Interrupted: The Constitutional Crisis in Copyright Law. Let's hear what Kevin has to say. So, Kevin, can you explain how current copyright laws are hindering AI's ability to access and use training data, and why that could limit the spread of knowledge?
Thank you so much for having me on, Caroline. I think I want to start off at a slightly higher level, which is just pointing out the purpose of copyright law to begin with and really focus on a key irony here. So, copyright law was designed to promote knowledge creation, and now it functions as a bottleneck in that knowledge ecosystem. So, today's AI systems face a sort of paradoxical constraint. They require vast oceans of human created content to learn, and yet our copyright framework increasingly cordons off those essential waters. So, if we think back to some historical parallels, for example, early publishers faced guild restrictions and royal monopolies that limited the dissemination of knowledge. And today's AI developers are now navigating a restrictive landscape through the barriers of copyright law. And I just don't think that's the way it should work out. So, to be a little bit more specific, copyright law is facing a bit of ambiguity as to how it pertains to the use of data, the use of copyrighted information in the training process. So we have these vast corpuses of copyrighted works, and we've seen that a lot of labs have managed to get their hands on that data and then use that data for training of their models. Well, the question then becomes, for that copyrighted information, if the lab didn't receive some sort of license or grant to use that information, does it qualify for the fair use exception under US law? And that fair use exception asks about the purpose of the use of data, the nature of the copyrighted information, whether or not it is a substitute for the data, and then getting at the actual amount of use of the copyrighted information. So you can see from those four factors, they're not very explicit. They don't come with a clear guideline as to how to break down when a fair use exception does apply that would allow a lab to use copyrighted data. And unfortunately, as you know, when there's ambiguity in the law, that hinders innovation. It leads to litigation and it leads to a real threat to, in particular, startups being able to determine whether they can use that copyrighted information in their training process. And so, as things stand right now, there's a lot of uncertainty around what sort of copyrighted information may be used by labs for training. And until we resolve those ambiguities, we're going to see startups really struggle to compete with some of these larger labs that have already amassed tons and tons of data through things like web scraping that has now become even illegal or prohibitively expensive for startups.
Yeah, thank you, Kevin. It's true that we forget sometimes that it's not just big companies doing AI, but that there's a lot of small, ambitious one waiting, and that's a good thing. Um, Looking back at the Constitution and the US legal framework, in your view, how do the original intentions of the intellectual property clause clash then with today's copyright framework in the context of AI development specifically? You talked about the spread of knowledge and science. How does reality, when it comes to the application of copyright law, not function very well in an AI environment?
Yeah, so Article 1, Section 8, Clause 8, for those who aren't looking at their handy dandy pocketbook constitution, says that Congress can promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So that's the intellectual property clause, what I'll refer to as the IP clause. Before we even talk about the IP clause in the US Constitution, it's important to think back to what existed prior to the Constitution. So, after the Revolution, while the US was operating under the Articles of Confederation, it was a patchwork of state based copyright protections that governed this regime. And the drafters of the Constitution realized they needed some mechanism to make sure that they were incentivizing the creation of new knowledge, of new innovation, new inventions. And they were trying to find out what is the best mechanism to use here. And there was a fascinating conversation that went on between Madison, for example, Jefferson, for example, where they said, hey, we really hate monopolies. We've seen in England, for example, a clear abuse of monopolies. We've seen that the royal prerogative has at times quashed innovation and has been used and abused by kings and queens over time. So, can we please come up with a better approach to incentivizing innovation? Well, they ran into a problem. The revolution was quite costly on the United States. The states themselves were in a tremendous amount of debt, and the federal coffers were nearly empty. And so when they were thinking about, oh, could we offer prizes? Could we offer premiums? One early founder in the US even came up with the idea, what if we gave 1,000 acres of land to anyone who came up with a new invention? So they were looking for any other alternative but copyright, but a monopoly right to use certain works. And yet, the fact of the matter was they just didn't have enough money to have those sorts of positive incentives. And so instead, they came up with this IP clause. And looking at the text of the IP clause, it's important to start off with that end that they were trying to focus on to promote the progress of science and useful arts. Now, not to sound too much like a lawyer, not to get too into the textual weeds, but that is a very specific objective. If something isn't promoting the progress of science, then it can't be interpreted as constitutional. It's flagrantly violating the clear end that the founders entrenched into the Constitution itself. So, what does it mean to promote the progress of science? And here there's been some really fascinating work done by some great scholars, including Larry Solom, that emphasize that the word promote in the Constitution is best interpreted as spreading. So, spreading that information as far as possible, not just creating more quantity of information or increasing the quality of that information or inventions or innovations, but actually sharing it as far as possible. Now, you may also be wondering, what does science and useful arts mean? Here again, some scholars have been very helpful in getting back to the original understanding of those words. And the short answer is science and useful arts just means knowledge, right? It just means knowledge. So the IP clause starts off, based off of those two observations, with a mandate that Congress spread knowledge. Okay, so if we have that goal in mind, it's really hard to see how the current copyright laws mesh with that idea of spreading knowledge. Caroline, before this, we had a great conversation where you and I were observing how copyright has evolved over time. So initially, we saw, for example, just a 14-year term for copyrighted works. Well, now it's continued to expand past 70 years. So if we see a 70-year protection of copyrighted works, that's a huge restriction on the ability to spread that knowledge. And we've also seen that copyrighted works aren't something that is made necessarily available to all innovators. We've seen that certain copyright holders, particularly ones with lots of lawyers and with deep pockets, are the ones who tend to enforce copyright more so than others. And so when we think through the term expansion in copyright, the folks who are actually enforcing copyright, it doesn't appear as though we're operating under the goal of spreading knowledge. And this is particularly important to point out in the AI context because AI, as pointed out by folks from William McCaskill to Sam Altman to everyone in between, whether you're a doomer or an accelerationist, I think everyone now acknowledges that AI tools are unparalleled in their ability to create knowledge. And so our question now is, can we spread that knowledge? Can we create legal regimes that actually allow for spreading those knowledge gains, for spreading those new innovations as far and wide as possible?
Thank you, Kevin. And actually, maybe it's a good thing that they didn't give land to it, because I can only imagine how Taylor Swift would have gone for a land grab. Um,
Louisiana Purchase would have been renamed the Swift Purchase, I guess, in that
yeah,
context, right?
exactly. I think we would have had the Louisiana tour instead of the Era tour. Um, Let me go to my next question, because obviously, having seen how it went wrong, or how it might not be exactly what was the intention, what specific reforms, changes to fair use or introduction of statutory licensing schemes, what could make sure that we get to a realignment of copyright law with the constitutional mandate that you mentioned to promote the spread of knowledge?
Yeah, so there are two things that I really want to focus on here. But first, I'll just start with a quick disclaimer, which is I'm very much focused on the use of copyrighted data for training. I think that there are real concerns and other questions that need to be raised by, for example, Perplexity and other search based uses of data. And we're going to see that play out in the courts. So I am focusing here on training and the use of copyrighted data in that context. And here I would like to see an AI training presumption. So under this would be a clear statutory presumption that if you're using works for machine learning, that constitutes fair use. And we need that sort of clarity in the law so that when we have startups and research institutions that are trying to catch up to all of these other massive labs, that they have an actual chance of developing high quality data sets, high quantity data sets as well, rather than trying to go through license agreement after license agreement after license agreement, trying to cobble their way to a robust training set. So that training presumption is one step forward that I think would be really positive. Another emphasis that I would put here is research safe harbors. So, research safe harbors would create absolute protections for non commercial research uses of copyrighted data. So, here it's just kind of taking that initial presumption and adding a +1 for if you're using that data for research purposes. I think we can all imagine the positive use cases of AI. We think about public health innovations that can come about. We think about that AI tutor that can help students who learn differently than their colleagues. None of that's possible if there's not robust data for those more positive use cases of AI. And so we really need to think through how are we going to empower research and nonprofit uses of AI by empowering them to collect and use data that's relevant in that instance. And then one broader reform that I think should be top of mind for all of us, and this is a bit challenging, so I welcome feedback on this proposal, but smarter folks than I have set this forward, which is the idea of data commons. So how can we begin to encourage people not to share their data with Google, not to share their data with Meta or OpenAI, but how can we share this data into data commons where we're putting in really sensitive but really high quality information that can then be used to train AI models and AI systems that are specifically tailored to the public good. So, here again, public health is a great use case. Imagine if all that data that your smartwatch is gathering during your workout was going toward training AI models that are going to help improve and detect when we're seeing some public health emergency. So, through data commons, we can imagine a more reciprocal relationship between sharing data and benefiting from that sharing that we don't see right now. And I think that's something that hopefully will be compelling. I'd also just encourage state legislators and federal legislators to, and I know this is something we don't always do well in the United States, but consider what other jurisdictions are doing. So here, having clear opt-out mechanisms, for example, as are available in the EU, looking at ideas like tiered compensation so that we're not just granting licenses or creating agreements with the largest content creators like the New York Times, but also thinking about how can we compensate folks who are less well endowed and less ubiquitous are things that should be top of mind. So really what I want to encourage people to think about is that AI is like fire. I mean, it can just spread so far if we let it, if we fuel it, if we give it the sustenance it needs. But if we instead come in with fire extinguishers right off the bat, then it's only going to be the folks who can afford their own kindling, who can go develop their own fire, who are going to benefit from this innovation.
Thank you, Kevin. I think that's a really nice image. Although I would hope that the fire is under control.
Yes, yes, very
And
much so. We don't want a conflagration. I should have specified.
exactly. So let's hope. I think a lot of people are thinking about these issues, as you said, and a lot of scholars and academics are working on this. So as the ideas I think get developed more, and as we mature in our discussions on AI, let's hope that innovation, respectful innovation, is at the center. And also thank you for telling the US to look at other examples like the EU. I'm sure the EU is very grateful.
Yes, but fingers crossed that we realize that we're all in this together, learning how to make sure, as you said, we pursue a responsible innovation path, but also making sure that this isn't just a world in which OpenAI, Anthropic, and Google create models that we all are locked into, but instead we have a lot of options and a lot of positive use cases of AI.
Thank you so much, Kevin.
Thank you.